Hi everyone. I want to chat a little bit about some of the copyright issues relating to the GLAM sector, but in particular just to explore a few of the interesting issues relating to the stream of research in ReCreating Europe relating to geography and the digitization of cultural heritage. And so what I want to start with here is the work in a public place. It could be a statue or a mural, or perhaps some other kind of work which may or may not be copyright protected. And I mean, I'm really using the word heritage here quite expansively to include works of art and architecture, sculpture parks, and perhaps also other outdoor displays of work that might be run or preserved by GLAM institutions. So one of the clear copyright questions around this is, well, when is it permissible to reproduce works that are located in public spaces? Now, as a matter of EU copyright law, we see that the InfoSoc directive provides for a so-called freedom of panorama, although those words specifically aren't used. Article 5 relates to the use of works such as works of architecture or sculpture made to be located permanently in public places. Now, there are a few difficulties here. One is that just in the wording itself, it's fairly narrow, but perhaps, depending on your point of view, a little more problematically is that this is an optional exception, meaning that member states have both implemented in different ways or indeed chosen not to implement it at all. And so in terms of the development of EU copyright law, and of course, ReCreating Europe is interested in particular in the Digital Single Market Directive, something to note here in respect of the work in public place is that the freedom of panorama exception could potentially have made it into the DSM directive. So it was highlighted, for instance, in the 2015 Reader report, and an unconditional, which is quite interesting, freedom of panorama exception amendment was considered before eventually being voted down in the European Parliament on the 6th of September in 2018. So the DSM directive doesn't include a freedom of panorama exception, and perhaps this doesn't really impact GLAM institutions. But it does seem to be part of a bigger concern about how the public can freely interact with certain types of cultural heritage. And I think that there's a common thread here about the ability to interact with, including digitize and share works, especially where those works are on public display. Next. So I turn now to the copyright implications for the digitization and sharing of works. First, to talk just a little bit about two-dimensional representations and then to move on to 3D works. And I suppose one of the core questions here for copyright law is a photograph taken within a GLAM institution, for instance, an object of an object itself an original work? So more specifically, perhaps, does the 2D reproduction of a work by way of a photograph, whether it's of an outdoor sculpture or a painting in a museum collection, demonstrate the necessary creative choices that would meet the EU author's own intellectual creation test? Now, at least in the UK, and I'm speaking here from the University of Glasgow, the case of Antiques Portfolio and Fitch relating to the reproduction of three-dimensional objects in 2D, the originality test in terms of skill, labour and judgment, but it's not really clear that the same outcome would apply under EU copyright law, in large part because it's uncertain that the personal touch, so following the Painter case, is in evidence. So a purely technical, even entirely excellent photograph of a work may not be one that attracts copyright. But on this broader point of GLAM digitization and public access to cultural heritage, I want to come back to the Digital Single Market Directive, but in a slightly more happily in relation to Article 14, which does appear to be helpful. So it states that, to quote, member states shall provide that when the term of protection of a work of visual art has expired, any material resulting from an act of reproduction of that work is not subject to copyright or related rights unless the material resulting from that act of reproduction is original in the sense that it is the author's own intellectual creation. So although Article 14 is geared in particular towards preservation and it doesn't solve issues of access and dissemination of in-copyright works, I think at the very least what we see here is that in the specific acknowledgement of the public domain, that this is something that is a welcome step. Of course, the question of copyright subsisting in such works remains relevant. Next. So similar copyright issues arise also in respect of 3D visualization of cultural heritage. And here I want to draw on work recently completed by my colleague Pina Orich, who is also part of ReCreating Europe. And she's written recently in the Gipitech journal on the 3D digitization of cultural heritage, and in particular looking at the copyright implications of methods, purposes, and collaboration. And she argues that in respect of laser scanning as the method of reproduction, the originality question may depend on the extent to which free and creative choices can be exercised either in the placement of the object by using handheld or backpack mounted sensors, or rather scanners, or indeed drones, the latter, of course, which would be particularly useful in terms of, say, reproducing public spaces or whole parts of public spaces. And then second, in respect of photogrammetry, questions also arise, but in particular in the process of the creation of these 3D reproductions, in particular whether they do actually meet the requisite creative choices test. And now in terms of both of those, and again looking at the question of the public domain, is that, are these works copyright protected? And to go back to the beginning of my presentation in talking about public space and why this matters, this is significant because it relates to access to culture, not only in terms of museum objects, but also really the ability of whole communities to experience places that, for instance, have perhaps been lost or destroyed, or are for any number of reasons inaccessible. So the image here, for instance, this really nice image where a person is sort of surrounded by this sort of beautiful paintings, is effectively a sort of like a virtual tour of Paris. And it sort of encapsulates both the importance of, I suppose, 3D and other kind of visualizations, but also in understanding exactly what the copyright implications of this are. And so the next point to mention here, and indeed my final point, is to think about what the copyright implications are sort of beyond 3D reproduction, perhaps to account for immersive digital heritage experiences as a whole. And here I want to highlight, and building on what Julia has said about involvement from interested parties and stakeholders, is that at Create in the University of Glasgow, there's another project that seeks to engage very closely with creative industries, stakeholders to develop an integrated policy approach to copyright in the EU digital single market. And the idea here is, as with the GLAM survey, to assist in the building of codes of best practice that are highly relevant to specific creative sectors. And the new codes will aim to capture existing community norms around the reuse of audiovisual materials in particular for both immersive heritage practitioners, but also documentary filmmakers. So I leave you with the invitation really to say that we welcome comments and suggestions as to what we should be exploring. And if you'd like to hear your voice heard in respect of all of these projects, to feel free to get in touch.